What are the factors that a court looks to see whether or not a change to maintenance is warranted or not?
So similar to
Welcome to the Illinois Family Law Insider Podcast. I'm Katie VanDeusen. I'm the managing partner at Sterling, and I have with me today Senior Associate Attorney Leah Diaz. Thanks for joining me today, Leah.
Thanks for having me.
So today we're going to be talking about post-judgment cases. So just because a divorce or a parentage case is finalized or completed, it doesn't necessarily mean the end of the legal process. Sometimes there can be post-judgment issues that pop up from time to time when it comes to either requesting to change or enforce those prior orders that were entered. So first, I kind of want to hone in, Leah, on modifications to child support in Illinois. So specifically, when can child support be changed after an original order was entered?
Usually there needs to be a substantial change in circumstance that occurs. There's a plethora of examples of what can react or what can kind of trigger a substantial change in circumstances according to statutes and case law, but changes in income, that can be whether you get a new job, you're terminated from the employment that you had previously, different like kids getting older and having more costs associated to like their day-to-day living expenses, things like that. So that substantial change in circumstances is what is typically required.
Okay. And then is there ever, in your experience, a situation where there would not be a substantial change in circumstances required in order to go back and modify or change support?
Yes, it's rare.
Yeah.
Usually, like it again, kind of like changes, like showing a need specifically for like a kid when it comes to like healthcare expenses or like health insurance for a child. Inconsistency of at least like 20%. The statute's really specific about this, but no less than $10 per week between the existing order and application of the guideline support, which is just that statutory support calculation. So things like that is where no substantial change in circumstance would be required, but it's not common.
I feel like I totally agree. It's not common. I feel like in order to not have a substantial change, it is so nuanced that like the percentage of cases that have that applicable is like so small. I think a majority of the cases that we see and we end up handling, like you do have to prove that substantial change. The only other kind of complicating factor too is if previously there was some deviation or some type of change from the statutory guidelines to now, I do think those cases kind of have to be looked at a little bit differently than your standard run of the mill case. So I totally agree. I think that without a substantial change, those cases or the timeframes where we see those things are just so rare that a majority of the time we have to rely on this substantial change in circumstance to really kind of trigger any type of change. So I know you referenced a couple of examples, Leah, like a change in job. Can you give any other additional examples of when a substantial change would rise to the level that would warrant a change in support?
Yeah, income is definitely the most common, especially when it comes to like modification of child support or support in general. It's usually an income change. And specifically when it comes to like income going down, that's also something that's a little bit difficult as well, because it has to be done in good faith in terms of income being lowered. So for example, like being terminated from your employment to no fault of your own and your income decreasing as a result, or having to find a new job and the market's changed, so your income is now lower. Like those things where it comes to like it is at no fault of your own income going down, really those are the situations where asking for lower child support is usually something that's looked at and can be awarded. Otherwise, income change going up is usually kind of when people are looking to modify child support or support in general, and that's most common. Change in parenting time is really common. That obviously requires a second facet of like your parenting plan changing at some level when it comes to parenting time. So, for example, if a parent isn't exercising 146 overnights in a calendar year, but now they are, right? And so they want their child support to be decreased because they are taking on a lot of those day-to-day responsibilities. They
Yep.
can ask for child support to be modified or lowered as a result. change in circumstances for like any type of health related issue. So again, that's kind of similar to like income going down. It's really to no fault of their own. Like some change in health has resulted in their income changing or their ability to earn income changing, their capacity to work at all those things can change. I will say when it comes to impairments of health, if you're not able to work, usually you're going to be entitled to some form of disability too. And that can get factored in when it comes to modifying support. So it may not be like a clean slate wash of you having zero income. You can be earning some form of disability. And if you aren't eligible for disability, the court's going to question whether or not you can actually work or not. So that's a caveat to any type of health related issues that can occur. There is also, just like every other statute that we see in Illinois, kind of like a catch-all that exists. That's what any type of change that's just equitable. I personally really haven't seen much that the court has looked at aside from these main three. But
Okay,
really, any change that's occurred that's substantial that impairs any type of ability to earn income or changes income, then absolutely child support can be modified.
definitely. What those are like such good takeaways, and what a good note in terms of the disability, kind of how you kind of want to look at that strategically and make sure that if that's a claim you're making, that you're also following up with receipt of disability to kind of show that that's been a change that's occurred. Or even I could assume, unemployment, you may end up receiving unemployment income, and that can still get factored in. So it may not automatically mean that you're paying zero in terms of child support. What a
Right.
great note. And then in terms of changes, when does a change go into effect, Leah, or how do people request a change when it comes to a prior order? Do they file something? Does it just automatically change? How does that work?
Most common mistake I see with people is thinking that just because they were let go or have been temporarily placed on furlough or whatever the case may be, that they think they can just automatically stop paying or lower their payments, which is the absolute worst route to take. In order for anything to go into effect, it's the court order that you guys follow. So whatever's entered with the court, that's what you guys have to follow until someone files a motion to request to change that. So nothing happens until you get a motion prepared and it's filed.
Absolutely. That's great to know. And when it comes to that data filing, I think we've seen in our practice, if you're the one who's seeking to make a change, you always want to at least request to go back to the data filing. It's not always automatic. But again, from that strategy perspective, you're always going to want to go back to that data filing moving forward. And then it's within the judge's discretion. But, it's always good to ask for that type of stuff.
Usually it's granted to mostly depending on the circumstances. It is usually within the judge's discretion on that. But usually what we see, especially if you're asking for a change in child support, you usually see the other party trying to delay, thinking that it's going to benefit them at some level. So usually when there's types of delays that occur and the judge, it's pretty clear to note that, it's more likely than not, a judge would be more inclined to go retroactive to the date that you filed. And specifically, if you know something's going to happen, within a month or so, you may want to get it on file sooner rather than later so you can be proactive about it and get it as soon as a change occurs and get that motion on file.
Absolutely. I totally agree with you. And in terms of your practice, Leah, let me ask you this. Have you ever seen a client who's kind of waited too long in terms of maybe a change that they've seen in their income? And has that ever had a negative impact on them where, maybe the judge either didn't go backwards in time, they delayed filing, and it kind of negatively impacted their ability to pay. And now they're kind of stuck with this back due child support amount?
Yeah, I mean, I've seen it happen quite often. The most common one is where you assume you can change or lower your child support when something occurs. It's specific in like weird, odd types of jobs too, like construction, for example. People get like furloughed over the winter where they aren't being paid during a specific period of time. So people, and you would think it seems like, okay, well, why wouldn't I just be able to do this for this like small period of time? But they decide they want to kind of change it or lower it during that time period. Sure, but how did you decide that number that you're going to pay? Did you talk to the other person about this? Because absent you you guys being on the same page with this. The order is what you guys fall into. And even if you guys are on the same page with this, that can change whether you guys are in agreement or not. So
Yeah.
truly, I've seen even some like sad circumstances where people have talked about it. It seems like they were on the same page, but lo and behold, they weren't. And now this individual is stuck not paying arrears, retroactivity, and in some cases, increases in child support because they're decided to kind of change things during a specific period of time.
Yeah, it's so tough, those types of cases for sure. You almost wish you could like go back in time and tell them like, come talk to me, let's get something on file, or, at least get a court order in place, memorializing what you guys are agreeing to so that you don't get stuck in those situations.
Yeah.
Okay, now shifting gears in terms of modifications to maintenance or spousal support. I know we kind of touched on child support, but shifting gears and talking about maintenance or spousal support. What is the rule in Illinois for making modifications to a support order for maintenance?
Super similar to child support, substantial change in circumstances. Also, really important to have a good attorney during your divorce proceeding because it also very much so depends on how your guys' marital settlement agreement or your order that was entered is drafted. There's even some random caveats that we've seen in terms of language within your divorce decree alone, where if that language isn't there, a judge could decide that you can't modify maintenance, even though it was your guys' intention to be able to modify it. So you want to be really careful about the language that's within your guys' divorce decree, because ultimately, if there's a question whether it's modifiable or not, you don't want that question to be something that you guys have to litigate.
Correct. So true. And I think that's probably one of the major distinctions that we see as attorneys is, child support is always modifiable. You can never lock that or set that in stone. As long as you can, of course, meet the legal burden required to make the change, you can always ask or request to make changes to child support. Maintenance or spousal support, though, there could be a set of circumstances where maintenance is non modifiable and you cannot come back in at any point in time to change it. And that, I think, is a big, I don't know, differentiation between the two. And exactly like you said, you've got to look back at the judgment. What did the original order say? Because that's going to, I think, determine what next steps are. And then in terms of practice, Leah, what are the factors that a court looks to see whether or not a change to maintenance is warranted or not?
So similar to child support in terms of like changes in income, employment, same types of things are going to be scrutinized in terms of like health, income being lowered. We're going to look at that carefully to make sure that it's all being done in good faith and it's not to the fault of specific parties. Again, lower income, especially when it comes to the person who's paying support, is going to be looked at and scrutinized a little really carefully to make sure that it's not being done intentionally to lower any type of support obligation. Additionally, to your point in terms of whether or not maintenance is modifiable or not, usually, unless you're dealing with like a very long-term marriage, usually maintenance is fixed termed or reviewable in nature, meaning it ends on a certain date or it's reviewable where you can come back and kind of see if it's going to terminate or if it's going to continue on or lower for a period of time. But effectively, in either circumstance, if somebody is becoming self-sufficient, kind of goes hand in hand with income changing, that can certainly result in maintenance being modified. But also if somebody's not becoming self-supporting or self-sufficient, that can also negatively impact somebody who's receiving spousal support, because the judge could decide to terminate it whether or not they are financially stable or not if they're not making efforts to become financially stable. New and increased expenses are things that are looked at too. That alone is usually not going to result in a modification, but it depends on what those expenses are, like health related expenses that we all knew, and now all of a sudden that expense has significantly increased. Sure, that's something I think that would probably meet that threshold, but otherwise that alone probably won't be enough. And then retirement, of course, as long as that is such an iffy one, depending on what county you're in, depending on retirement. I've had one judge in Cook County constantly quote to his mother being like 85 and still working, so everybody else can too. And then I've had judges in McHenry County say police retiring at 55 is perfectly. So really depends on county when it comes to retirement, but the term we'll use is reasonable retirement when
Yes.
substantial change can occur. And then there's statutory factors that just automatically result in maintenance terminating as well based on certain events taking place. So that's things like death of parties, remarriage, or cohabitation.
Got it. Okay. And so I know you kind of referenced the termination factors. So that's death of the parties, cohabitation, or remarriage. Like, how would you go about maybe proving, remarriage or cohabitation? Like, what effect would that have? Or how would you even go about starting to do those types of things?
So with remarriage, I mean, cohabitation is definitely a more difficult one to go through in terms of kind of figuring things out and really being able to prove cohabitation is occurring.
Mhm.
But unfortunately, at some level, the onus does fall on the person that is paying support in terms of, do they know somebody, do they know their former spouse remarried, do they know that this person is cohabitating with somebody new? And once they kind of have an inkling of something like that, we talk through it, and then you want to file something, you want to file a motion. And once that motion is filed, you can start requesting discovery, so you can kind of look into things that and have them provide things to show, or at least build a case for whether or not remarriage or cohabitation has occurred. Remarriage is easy. You're really just asking for like a marriage certificate or something like that to be able to prove remarriage took place. For cohabitation, that's certainly a lot more difficult and it's really nuanced. I kind of say that there's like a trifecta that you need to show in order to be successful on that. But really it's, are people living together? Are they engaged? And are they commingling finances at some level? So it's really difficult when somebody comes to me seeking cohabitation and seeking to terminate maintenance as a result of that. But throughout discovery, you can, as long as things are going your way and you're getting the discovery that you need, you could be successful in cohabitation. Commingling of finances is something that you really want to make sure is happening, though.
Yeah, that's like for sure a cornerstone. And like that they're holding themselves out as kind of like a married couple. There's some type of financial support occurring there where that would trigger, no longer being a need for the ex spouse to continue to financially support that individual. But yeah, I totally agree with you. In practice, I think it's a very high legal burden to prove cohabitation versus a modification or possibly even like a termination based on remarriage. I think those probably are going to be more straightforward most of the time. And Leah, have you ever seen a case where maybe, either person who was paying thought that the other party who was receiving maintenance was cohabitating, or maybe someone who was receiving maintenance all of a sudden getting hit with a petition to terminate and just being completely blindsided?
I actually did represent a client who wanted me to look into cohabitation. He believed it was occurring. In that situation, I will say those circumstances are a little bit easier when parties have kids together because kids, whether or not you're asking for the information, just tend to offer it up sometimes. And
Yeah.
so he was learning through the kids. He really wasn't prying too much. He made sufficient income, so he wasn't really looking into it too much. But he was hearing from his kids that his ex-spouse was living with somebody, that they were engaged, that they really wanted to get married, and I think he knew she was being smart enough to not commingle finances together. So we were in a really tough spot when it came to that. He did still want me to proceed and file because he did believe that they really wanted to get married. I told him if we were litigating, it was going to be really difficult if they weren't commingling finances at any level. And it actually resulted in an agreed order being entered to terminate the spousal support after a period of 3 years. And the reason being is because they did want to get married. And so the caveat to that agreed order was that they'd be allowed to get married, but despite that, the maintenance would terminate after 3 additional years. So honestly, I think that's one of the most successful ways you can go on this type of issue. It's really hard to be successful in litigation on it.
That's true, and then that person still at least got that termination date, right? Like, secured
Well,
it, and it wasn't a question of having to come back in and continue to litigate or rehash all of these things.
yeah,
Wow.
yeah.
And then what would you say are the most common mistakes that people may make or that you see when it comes to modifying support?
Not knowing that their prior judgment won't allow them to. That's like the most heart-wrenching conversations to have with clients is they really didn't read their divorce decree. If there's any bit of advice, go into detail of your divorce decree with your attorney at the time. Make sure you really understand what you're signing. I've had multiple clients come to me seeking to terminate maintenance, and their judgment and marital settlement agreement would not allow them to do that. It was permanent in nature. So we could at least seek to modify regardless of whether it's, permanent, right? But at least we can modify it. But that's definitely the biggest mistake we see is somebody coming in is really excited about doing this or really wanting to do it, and then you having to inform them that they can't. So biggest takeaway is to really read through that divorce decree.
I agree. The only other thing that I could add to that is I've definitely seen cases where people they wait to file, and then they think they have some verbal agreement with the other party, and come to find out they change their mind. And then that person seeks, counsel through an attorney and knows that they legally can go back in time, and ask for the, whatever amount is set forth in the order. And it's so heart wrenching to have to tell a person, like, even though you verbally may have agreed to this, the order is what the order is. And those people that wait so long to take action, it just makes it so difficult. And those, I think, are also some of the hardest discussions we have too. It's really tough. So, in terms of major takeaways, Leah, what would you say is the first step for someone if they think that they should be taking steps to change support? What would you tell them is the first thing they should do?
Consult with an attorney right away. Talk with an attorney and figure out where or what your facts are and how that would warrant a modification.
Absolutely. And then what would you say is your best advice or your main takeaway for someone who may be struggling to keep up with payments, may already be behind, and they're kind of wanting to know what their options are for making a change to the prior order?
I think first, and sometimes I think people kind of forget this because they get what you're ideally supposed to do is have these judgments, tuck them away, and then just kind of be following them and working together, is really make sure that you too are following the terms of your agreement. So if you're getting behind on payments and you're wondering what's going on with the other person, most likely than not, your guys' agreement probably has some form of exchange of finances you guys are supposed to do each year, or be able to kind of look in terms of, a yearly exchange of what's going on so that you can see what's going on with the other party's finances and they can see what's going on with yours. So that takes away a ton of the mystery when it comes to any type of modification. Is you really should have that at your fingertips each year. So being diligent about those types of things and not, letting it fall by the wayside is the biggest bit of proactive advice I could give anybody on this, especially when it comes to if they're actually struggling to make payments, because they should be able to see what's going on both sides and file as soon as possible if there is some form of a change.
Absolutely agreed, Leah. Well, thank you so much for joining me today, Leah, talking through some post judgment issues when it comes to changing support, modifying what was originally entered, and kind of how you can go about doing that with both child support as well as maintenance or spousal support. I really appreciate all the kind of takeaways and the knowledge and experience that you bring to the table, Leah. So thanks for joining me today.
Of course, thanks you.
Many people wait too long to act on support issues until the damage is already done. But delays around joint debts like the mortgage can be even more devastating. If your ex has stopped paying, there are critical steps that you must take immediately to protect your credit and your home. Watch this next episode to find out exactly what to do before it's too late.